Are you having a problem with the amenities in your building? Well, amenities are usually common elements, so if you're having a problem, maybe the other tenants in your building are having the same problem. Could a class action lawsuit be an economical and easy way for you and your neighbors to take collective action against your landlord to fix whatever is wrong? In episode 51 of the Tenant Law Podcast, we look at a case where the tenants did just that. Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. It's been a minute since I dropped an episode on the Tenant Law Podcast. That's not because I have abandoned you, valued audience. On the contrary, I've been exploring importing this show, or a version of it, onto a real podcast network. I'm unsure if that's actually happening, but I recorded 3 demos for the network. So while I wait, I'm going to upload some of that material here. This episode comes with video if you're consuming it on Spotify, but you certainly do not need to watch any episode of my podcast. The video here is just some simple slides and a picture from a document in the case we're covering today. I'll never make an episode that my audience can't benefit from by simply listening. So please enjoy episode 51. Okay, as always, we're going to start by setting the stage with some context. First, we're going to talk about class actions in general. A class action is a lawsuit where a small group of people called the plaintiffs sue on behalf of a larger group of people called the class. And everyone in the class has similar claims against the defendant. These lawsuits are designed to provide a practical and economical way to address issues affecting many individuals, such as those that come from a defective product or a deceptive business practice. You see class actions in those contexts a lot. For a case to proceed as a class action, you can't just bring one and decide yourself it's a class action. A judge has to give you permission to proceed as a class action. And the court will look at the case and decide, is the group large enough to make individual lawsuits impractical? And do these claims share common issues of fact and law? So that law is codified at New York State Civil Practice Law and Rules, Article 9. I'm going to give you an example of a class action that I knew a lot about because a friend of mine was one of the attorneys for the class, for the plaintiffs. The Happy Birthday to You case. So apparently, in 1988, a company claimed that they owned the copyright to Happy Birthday to You, and they charged royalties for it. So every time someone would use that song in a movie, in a TV show, on the Broadway stage, or at a restaurant that did birthday parties for kids, wherever it was used, people would have to pay royalties to this company. In 2013, a filmmaker filed a lawsuit against the company saying, you don't own the copyright and you should give me my money back and some damages. And that was brought and allowed to proceed as a class action. In 2015, a federal judge ruled that the company did not own the copyright, and a $14 million settlement was reached. So the class members and their lawyers split the $14 million. Most class action attorneys are hired on a contingency fee basis. That means they get a percentage of what they win. It's usually 25% to 35%, and if they don't win anything, their clients don't pay anything. And the court must approve these payment arrangements. Class actions are difficult to prosecute. It's a whole other overlay on litigation when you're doing a class action. So now let's talk about class actions in New York City landlord-tenant law. All right, so in the last decade or two, tenants have started bringing class actions against landlords on complicated rent stabilization coverage issues in New York City. For example, it's now well settled that a qualified plaintiff may use the class action vehicle to recover rent overcharges against landlords who deregulated apartments, even though the buildings had tax benefits that would have otherwise prevented that in contravention of the rent stabilization laws. I covered a case just like that, and I must say I found it very difficult to convey to people the important parts of class actions and to teach that, as I was simultaneously having to deal with a very complicated rent stabilization coverage issue. And then I saw this case. It just came down in August of 2025, and it's a class action by New York City tenants against a New York City landlord, but it's not about a complicated rent stabilization issue. In fact, it's about a pool. Okay, so today's case is called Lee versus Columbus Square 808 LLC. This is a case coming to us from the Supreme Court of the state of New York in August 2025 is when this particular decision came down. Now remember, whenever I talk about the Supreme Court, I'm not talking about the highest court in New York State. The Supreme Court is the lowest court in New York State. It's the court of original jurisdiction, the first place that you would go to have your trial, and that's where this case is in New York County. So in this case, according to the complaint, the landlord advertised this building in Manhattan as having a nice 3-lane pool. Actually, if you're watching me, you can see a picture of the pool in question. I pulled these pictures from the complaint. If you're not looking, it doesn't really matter, but it shows a very happy, very handsome one guy swimming or sitting on the side of a 3-lane pool with nobody else in it in this well-lit, beautiful place. The complaint in this case says that ads for the building showed a big, beautiful, empty pool with one guy swimming in it, and both the building's website and the sign on the door to the pool said that access to the pool is open to all tenants in the building from 6 a.m. to 10 p.m. on all weekdays, and then there were weekend hours as well. The problem came up when the tenant, who is the lead plaintiff in this case, signed his lease and moved in and discovered that the building rents out 2 of the 3 lanes of the pool every day from 10 a.m. to 6 p.m. Monday through Friday, not to anybody in the building, but to an outside company that uses the 2 lanes for a swim school. And so from 10 a.m. to 6 p.m., 5 days a week, there's only really 1 of those 3 lanes is available to people who live in the building. And according to the complaint, that was not something that tenants find out until after they sign their lease. So the tenant sued for breach of contract and for some other things. And in today's decision, the court was granting the tenant's application to proceed in this case as a class. And I'm going to do a tiny bit of reading, tiny bit of paraphrasing. The law is words. Stick with me. Plaintiffs established the prerequisites to a class action under Civil Practice Law and Rules Article 9, in that 1, the class is comprised of at least 40 residents of the building. That's a lot of people, so that makes sense. Instead of having 40 separate lawsuits, you're going to have the 1 lawsuit. 2, there are questions of law and fact common to the class, to wit, whether owner breached their contract with all lessees in the building when they rented out the pool to a swim school. And the court concludes, a class action on this breach of contract claim is superior to other methods available to litigate the issue. So the court allowed the class to be formed. To prepare for this episode, when I see a decision I want to talk about, I usually go and I look at the case on the court's website, and I'll look at the complaint and other decisions in the case. And I looked at the briefs leading to this question about whether or not this case gets certified as a class action. And I thought it was interesting because the defendant landlord was trying to argue that, well, this can't be a class action because everybody's claim would be different. Okay, so I figured the next thing the landlord was going to tell us was that different leases had different clauses when it came to the pool, but they didn't say that. What does the lease say in this case? It says there's a pool. There's a pool in this building. And then here's all it says. Pool hours are posted at the pool. That's the contract. There's a pool and pool hours are posted at the pool. Obviously, the problem here is if the pool hours are posted at the pool, that means that the landlord has discretion to set the pool hours because the landlord is the one posting the pool hours. The reality is, though, the pool hours were posted twice. This is what the complaint tells us. There's a big sign on the door that says, oh, you can come in this pool from 6 a.m. in the morning to 10 p.m. at night. But then apparently they also post a second set of hours that disclose this, well, for half the time, you only get 1/3 of the pool. And it's in smaller type and you don't get to see it until after you sign a lease to be in the building. So is that a breach of contract? There's a pool and the pool hours are posted at the pool. Well, if I'm the landlord, I'm going to say, well, you have the pool and the pool hours are posted and the smaller print hours say that you get 1/3 of a pool half of the time during the weekdays. Okay, but then again, they're posted twice. So is that ambiguous? But now you're looking at something outside, extrinsic to the contract to be able to interpret the contract. This would be easy if the landlord had said, hey, there's a pool, but you get to swim in it 1 hour at 2:00 in the morning on Sunday night. That would be tantamount to there really is no pool, so you're not delivering on your contract promise that there is a pool. This would also be easy if the swim school was only there for 1 hour a week, because then you still have a pool. Okay, well, there's an hour restriction. You'll live. This is so in the middle, it feels to me. I mean, really, I wouldn't like to be in the position of these tenants. But then again, all the contract says, all the lease says is there's a pool and the pool hours will be posted at the pool. In our takeaways, we're going to say a word or two about amenities that can probably really help people in the future. So before we get to our takeaways, let's do the housekeeping. This is not legal advice and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If this is legal advertising, it is terrible because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe and give us the highest rating. Okay, at the threshold of the tenant takeaways, let me say that in this episode, we've been exploring a case where a class of action by tenants against the landlord as a way to deal with an amenity problem that all the tenants shared. But I should say that class actions are not the only kind of collective action available to tenants. The tenants in this building could have, and for all I know, maybe they did, organize a tenant association to push back against the landlord in various ways. We're going to have an upcoming episode on just exactly that topic. But for today, let's finish looking at class actions and say a few more words on amenities, even in small buildings. It's time for the tenant takeaway. Tenant takeaway number 1, we're going to talk about a pro of class actions. First of all, never even consider doing a class action with a lawyer who's never prosecuted a class action before. This is the kind of thing that a younger lawyer would learn in an apprentice capacity from more seasoned lawyers. It's high art, it's complicated, there's a lot to it, and there's lots of ways it could go wrong. So only use experienced class action lawyers. If you're considering joining a class, it's probably brought by an experienced law firm. So one of the pros of class actions is that you are getting good lawyers. Also, a class action is going to be heavily litigated because landlords expect to get sued by some tenants some of the time on some things. They don't expect to get sued by all of the tenants and former tenants and maybe future tenants or whatever. A class action is extremely aggressive and landlords will fight hard against them. The lawyers who do this stuff understand this. And you're on a contingent fee basis. So one of the pros of a class action, as opposed to bringing your own lawsuit, is you're getting good lawyers for free. Takeaway number 2, I kind of already covered, and this could be a pro or a con depending on who you are, but class action is aggressive. It's aggressive because it's collective action. And if you're someone who's very community oriented and you want to right wrongs, a class action is a strong mechanism for that. Takeaway number 3, we're going to start talking about some cons of class actions. In a class action, you have less control than if you brought your own lawsuit. Once you join a class, you don't get to make decisions for yourself anymore. You have to make decisions with the class. So if you get to a point where you say, I don't want to do this lawsuit anymore, I just want to be done with this, I want to settle or I want to drop it, you can't do that without the class. Or if the class is settling and you don't love the settlement, you want to go to trial, again, the class and the class lawyers are going to be putting pressure on you to go with them. You don't get to make decisions for yourself in isolation in a class action. You have less control. Takeaway number 4, another con of a class action is class actions take forever. Cases these days in New York courts take forever. And if you put in the overlay of a class action, it really takes a long time. In this case, let's just use the case in front of us as an example. This case began in January 2023, and the class was just certified in the decision we looked at today in August of 2025. So it took them 2.5 years to get their class certified, and it mentioned in the end of the decision that discovery was starting. And so, they're really kind of at the threshold of parts of the case. So class actions take a long time. Takeaway number 5, and this isn't just about luxury buildings with pools and dog grooming stations and barbecues on the roof. This could be about anything. If there is something that's important to you about a housing arrangement, you need to make sure that that something is in your contract. So let's take it in another direction. Let's say you're renting the first floor of a 3-unit building in Queens, and you and your partner are avid bikers. You have expensive bikes. That's your main form of transportation. You're passionate about biking. You ask your landlady, can we lock our bikes in the basement of the building? The basement isn't part of your apartment, but you ask for that permission and she says, sure, and gives you a key, and it's secure and it's dry and you're happy and your bikes are down there. It's all good. But then, God forbid, your landlady dies and her son takes over. And he comes in and says, I'm selling the building, get your junk, get your bikes out of the basement. Or I'm putting my weight room down there, get your bikes out of the basement. You say, but wait a minute, our former landlord, your mother, said that we could always put our bikes down there. That's when it becomes important, did you put it in the lease? In the bike example, you could probably just write it on the main lease and have the landlord initial it. Do a lot of homework, research the building, look at reviews, look at social media, in particular for the amenity feature that is important to you. And if you can, paper it in your lease. And there you have it. The law belongs to you, New York City, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I'm Michelle Itkowitz, and this is the Tenant Law Podcast.